everyone. Tal Williams, corporate and commercial partner at Holman Webb, joins me today to discuss the COVIDSafe app and the privacy implications of it. Hi, Tal.
Good morning, Adriana. How are you?
Good, good. Look, this new app seems to be raising some pretty intense questions from what I gather. Now, one of the main things that people are concerned about is the collection of data. I know with Google, we're exposed to all manner of, I guess, invasion of our privacy. You know, they take the language you speak, your name and password, your phone number, emails you write and receive, your location, documents and spreadsheets you create, even your purchase activity. I mean, the list goes on and on. What sort of information are they collecting with this new app?
Yeah, you're right, Adriana. The list for Google does go on. You've probably listed about 20% of the information they actually collect and which we consent to them collecting. Well, compared to that, this app is very, very limited. They ask you for your name, but under Australian privacy principles, you don't need to give your actual name. You are actually able to put in a pseudonym instead of your actual name. They ask you for a postcode. They ask you for your telephone number, and they will verify that. In other words, they will send a message to the number that you put in with a verification number that you need to respond to. So you do need to have the phone with you. It could be a burner phone though. It doesn't have to be your regular phone. And they also ask for your age, but it will be a range. It won't be a birth date. It'll be a 5-year range they'll ask you to select. And that's it. That's all the information they're asking you for. Okay.
So we understand that potentially it's very safe as an app technologically, but really how safe is it for consumers from a legislative perspective?
2 points to make there, and the first one is, as with most things in this COVID situation, the government makes announcements and says they're going to do things, and this is one of those examples where the government has said we are going to legislate for this, we are going to bring something into place in May sometime. So the actual legislation, principal legislation that backs this up hasn't yet been passed. So we're not sure what that's going to say. In the meantime, however, they have passed a determination under the Biosecurity Act, and that determination sets out what you can do, what you can't do, a whole lot of other things in relation to the use of the app and access to the app. And it also, because it's under that act, a breach of that determination results in particular penalties. Quasi-criminal penalties, i.e. jail time, being enforced if somebody does choose to breach the act. So it's a little bit more than the protection you get under the Privacy Act, because there is jail time involved if there is a breach by somebody, but it is not as good as actual full-blown legislation, which hopefully will be forthcoming in the next couple of weeks.
Okay, so we've had a lot of debate around this in our office, and I'm sure other people probably have. Are we in a position to enforce employees to download the app before they come back to work?
Look, in one sense, you'd say that's a very sensible thing to do for employee health and welfare, to make sure that everybody's got it so that you can protect your staff. People can home isolate if they need to, if they've been exposed. So in one way, you'd be saying, well, that's actually not a bad idea. Unfortunately, fortunately or unfortunately, the determination expressly deals with that issue. You cannot coerce anybody to download this app. It is entirely voluntary. So as an employer, it is not possible for you to say you must download this in order to come to work. And in fact, the determination expressly says nothing can be stayed in relation to employment. Protective action is not able to be taken in relation to this. Anything you do to coerce someone to download this is inappropriate and a breach of that determination. And like I said, there are severe penalties, 300 penalty units and 10 years jail for a breach, up to those amounts. So as an employer, short answer, no. You cannot coerce an employee or require an employee to download the app.
Tal, the other question I wanted to cover was, we have an American company, Amazon, collecting the data. It's being stored in Australia, but how well is our data protected as a result?
That's a good question, Adriana, and the answer is somewhat uncertain, both from a local Australian perspective, but also in relation to what powers the American authorities have in relation to Amazon being an American company. So we don't know the answer to that. We don't know whether or not American subpoenas would apply to the information, because it's an American company who would be receiving these subpoenas, even though the information is stored in Australia. So that's one question. And even with the Australian situation, there are existing rights of government, law enforcement agencies, ASIO, the police, to access information appropriately, and they're enshrined in legislation. And the question is, does that legislation trump the subordinate determination that's been made under the Biosecurity Act? So they're unknowns at the moment, and hopefully will be remedied when the legislation actually comes through, because that'll raise the protection level within Australia. But they are unknowns. But I've got to add, the information that is going to be there could be your name if you choose to put your name in, but it could also be a pseudonym. It will only be an age range that is available. It will only be your telephone number, which might be a temporary number that you have. So it's not, particularly, compared to what Google has on us, sensitive information. Exactly. And very difficult to identify you. Maybe your telephone number would be the most identifiable component if you don't put your real name in. But even if they do have access, the question is, well, what are they actually getting? Yeah,
and my final question is, who's supervising all this? I mean, is there a department, or, where's our recourse?
And another very good question, because the answer to that is entirely unknown. So under the determination, and certainly under the government announcements, there's no one who's seems to have been given the authority to monitor, to supervise, to ensure people are complying. And at the moment, not even anybody who's reporting on the success or otherwise. Now, we're assuming that someone in the government is doing that, but there isn't a particular authority that we're aware of, or we've been made aware of, who is actually supervising. I know the Law Council of Australia has raised this as an issue, saying, well, who's looking after this? Now, certainly when there's a breach, then the Privacy Commissioner and whoever administers the Biosecurity, Department of Health probably, they will be able to come into play and action. And for the criminal component, because under the Crimes Act, there might also be a computer-related crime, they can come in, but that's only after a breach. Who's monitoring it now and making sure this is all working properly? We're a little bit uncertain.
Thanks for your time, Tal.
No problem at all. Thanks, Adriana.